and we have looked at the first two topics. I just wanted to confirm from your class representative. Did we clear with the law of thoughts? Confirm? Caesar and Alvin, did we clear with the law of thoughts? Can you hear me? Caesar and Alvin, did we clear with the law of thoughts for both of you?
Yes.
Okay, I'll clear today.
For us, you gave us an assignment on law of thoughts. You are to discuss it, but we didn't have that class because you are allowing us to study for the CAT that is supposed to be on Wednesday.
Hello, you're saying?
I'm saying you are to cover the law of thoughts, so you gave us an assignment on the same. So we were to have that class on Wednesday, but you gave us that time to revise for the CAT that will be on Wednesday.
And is your CAT today? Is it supposed to be now?
No, on Wednesday, 9 a.m.
Oh, okay. I almost ran there.
No.
Okay. Now, I had introduced, or I was introducing, I'm sure for Alvin's class, had covered quite extensively. Is that the position?
Yes, we covered quite extensively.
Okay. So having covered quite extensively, yes, ma'am. They'll just finish. Then you collect. They don't take too long. Okay, thank you. Mark, tell them that I have another class. I have Alvin's and Caesar's class. So I can't, yeah, so that's why you're standing in for me. Okay. Sorry, we are conducting CAT with Daisy's class. So I needed help from my colleagues. Now, we had looked at, I think I had introduced, and what I said is that the law of thoughts is a civil wrong. Thought is a civil wrong, which arises out of breach of duty, and that's basically negligence. Okay, so when we are looking at the law of thoughts, okay, and assessing the specifics within the same, there are certain specific thoughts that are prevalent to, or that engineers have exposure to, and that is careless acts and negligent advice. You realize that advice arises out of consultancy, and acts arises out of the process of doing or undertaking the obligation. So an engineer can find themselves in problems within the law of thoughts under the careless acts. That is errors in calculation and poor supervision. And they can also give negligent advice, where they're telling somebody something that probably does not exist in terms of application, or they undertake an obligation that ends up not being valid, as it were. Okay, so those are the two scenarios where an engineer can find themselves in problems when it comes to the law of thoughts. And this falls under matters professional negligence. Why? Because as an engineer, you're expected to act professionally and within the confines of your training. So if you do not act professionally, then it's professional negligence. And this is with regard to the standards of care that the law has set before you, okay? So you cannot do that which is not provided for. And then, of course, we have contributory negligence. And contributory negligence is a situation where you are undertaking your obligation well, but somebody gets injured or something happens within your institution that is falls within negligence or careless act. Then there'll be an indication that you contributed towards that negligence and therefore liability should take place. Okay. There are two kinds of injuries within the law of torts. There is one that is voluntary and there is one that somebody has not signed for. Example, if somebody goes, let's use a practical social example, where somebody decides to join, let's say, a football game, a football match, okay? Under those circumstances, it will be very clear that they have signed for the risks arising out of that, okay? So they cannot say that if, let's say, a ball hits you so badly and maybe you break your teeth, you can't say that you didn't sign for those risks, okay? So that would say is a situation where they voluntarily signed for that risk. And then we have vicarious liability. That is where a person commits a tort. Let's say your servant, okay? Workers. Sorry, you have workers and they're undertaking obligations for you. Then something happens that leads or triggers a situation. Then that is vicarious liability, okay? And they say that it is liability that ensues to you because somebody was acting on your behalf, okay? So if somebody is acting on your behalf, your employee, and then another person gets injured or something happens through professional negligence, then you'll be held liable, okay? So what are the various torts, okay? Or what are the various defenses that one then would put forth and say that, you know what, under this law of torts, yes, I did my best. I've done everything that I ought to have done to prevent me, sorry, it's coming, to prevent me then from liability. What are these circumstances? Okay. And one of the general defenses, I said that in tort, it is the law, it is equity that comes into play. And therefore, if somebody fails to act according to, within the agreed premises, then the other person would essentially be, the very person, the professional is the one who will be held liable. So what are the circumstances under which you would not be held liable under the law of torts? One of those is volenti non fit injuria. Volenti non fit injuria. And what is volenti non fit injuria? Volenti non fit injuria is a situation where somebody finds themselves in problems, okay? And they voluntarily okay, which they voluntarily did what? They voluntarily signed for it, okay? And I've given you an example, that example of joining a club and they're taking activities and you sign for it. But for an engineer, voluntary and fit injurious circumstances where you have explained to your clients that you are not able to meet the obligations that they are bestowing upon you. But they say that no problem, you know what? I trust you, Caesar, and I'm giving you this work. Therefore, don't worry. I know that whatever eventualities can come out of it will be taken care of. So under those circumstances, they voluntarily signed for that injury and they should be done what? They cannot blame you. Why? Because you forewarned them and you told them that you would not take responsibility for their actions, okay? Then we have inevitable accident. Inevitable accident, where an accident occurs, okay, within your place of work. Maybe you are undertaking work for a client and then an accident occurs that is beyond the comprehension of all parties involved. Under those circumstances, then you would not be held liable. That is inevitable accident. Then we have act of God. We all know that there are certain circumstances that are beyond us, like COVID. So if a client gives you a contract and then a COVID situation happens, that would be an act of God. And then the country probably is shut down the way it happened. You can't be held liable, okay? It would be an act of God and nobody should expect you to act accordingly, okay? Then there is a necessity. If you act out of necessity, example, you are undertaking your obligation and then a situation occurs where you're supposed to save face, okay, for the sake of the client. Let's say maybe you're working with dangerous machines or tools, okay? And it so happens that they're going to harm somebody, maybe within the site. And when you're going to save this person, you cause greater harm. You will not be held liable as a professional because you are acting out of necessity. It was necessary for you to undertake this obligation for purposes of avoiding greater harm. Then we have self-defense, okay? We have self-defense, where you're acting in a situation of self-defense is where probably you are attacked, okay? Where you are attacked, somebody cannot hold you liable for the type of injury or the extent of injury that you'll exert when you are attacked. So you'll be acting under self-defense. And then there is mistake. Mistake can be to the existence of a certain subject matter or a certain situation. Example, when let's say a client has given you work to do, okay? And then maybe they've given you their site. Then in the course of that, you have your tools, which maybe you had left somewhere. Then in that premise where you had left your tools, probably fire breaks out and raises down everything. You cannot be held liable for what essentially would happen under these circumstances. Why? Because whatever happens is a mistake, not on your part, okay? And if you're not able to undertake your obligation because of this mistake, you cannot be held liable, okay? Because it was not intentional, but it was a mistaken belief of existence of that particular state of affairs. Then we have statutory authority. When somebody is acting under the law, like you as a professional, you're acting under the provisions of the law, under the color of your office, you can't be held liable. That is a statutory authority. Then we also have exemption clause or disclaimer clause, where you've signed an agreement and you've agreed that you'll not be blamed for anything that so happens. Why? Because it is something that parties were able to foresee, and this person has entered this agreement with that understanding in mind. Under those circumstances, you cannot be held liable. So those are the various exceptions under which somebody cannot be held liable under the law of tort. And especially for you as a professional, there are things or circumstances that would then be excused. Is there a question? Is there a question? Okay. There's no question. Now, having looked at the exceptional circumstances, we want to ask ourselves, who can be sued and who can sue under the law of torts? Because it's not everyone, every entity that can sue or be sued under the law of torts, okay? One of those is, can the government sue or be sued under the law of torts? Okay? The government can sue or be sued under the law of torts, but there are certain exceptions, okay? It can be sued when probably it's a servant acting or agent, or in respect of duties or obligations that are owed back to the servants. However, there are certain situations when the government cannot be sued, okay? Example, when the government is undertaking its obligation to its citizens, it essentially cannot be sued, Okay, so if you can prove, unless you can prove that this officer acted negligent rather, ordinarily you cannot sue an officer in the course of their duties. Then infant and minors, just like an infant and a minor cannot enter into a contract, the same way they cannot be sued under the law of torts. It's the guardian who will take up that liability, if at all. Husband and wife, a wife can sue her husband in tort for protection and security of her property. And both spouses have the capacity to sue and be sued under the law of torts. Whether the president can be sued, a sitting president cannot be sued under the law of torts, neither can head of states and diplomats. A corporation can be sued under the law of torts, and this occurs when officers acted beyond the prescribed powers or authority under the law. Okay. And so persons of unsound mind cannot be sued because they would not ordinarily understand what you're talking about. Aliens can be sued, but an alien enemy cannot be sued. Okay. Judicial officers cannot be sued if they were acting within the presence of the law. Okay. So those are the circumstances under which segregates the kinds of persons who can be sued under the law of torts and those that cannot be sued. So as a professional engineer, when you are under those various heads, there are circumstances when you can be sued, and there are those circumstances when you cannot be sued. Okay? And of course, we have vicarious liability and strict liability. I explained in the course of the last class, where I was saying that for strict liability, this one, if a situation occurs and it's under strict liability, you are held liable and you cannot wiggle your way out of it. While vicarious liability, you can wiggle your way out of it. So what are the various torts? What are the various specific torts that we can say are there within the law? Okay, so not all civil wrongs fall under the law of torts. There are certain specific torts that are provided for that are glaring. And I told you that you'll never get a book. You'll never come across a book that does what? That calls itself codification of the law of torts. Why? Because there is nothing like that. Okay. So one of those is trespass. Okay. Trespass can be to property or to person. Trespass can be to property or to person. Example to property, generally trespass to property is getting into somebody's property without their consent, that is trespass, or theft. Theft is also trespass. Theft is where you take somebody's movable property without their consent. Movable means that can be moved from one place to the other, like your desk, your pen, your your clothes. That's theft, and that is trespass to property. Whereas trespass to person is where you hit somebody, that is, there is battery, there is assault. When I try slapping you like this and it doesn't hit you, that I say this assault. But when I essentially hit you, that is trespass. When I essentially hit you, that's battery. So battery is trespass to person, where you hit somebody. You exert force, and that force causes somebody to suffer harm. Whereas for assault, you try hitting somebody, but it falls short, but they suffer psychological harm. Okay, so that is what that is assault. So trespass can be trespass to person, trespass to property. Trespass to property is where you go into somebody's property without their consent, or you steal. That is theft. You take somebody's movable. It's only in Kenya where people steal land. Generally, land is not subject of theft because you cannot move it from wherever to another place. Okay, whereas other goods that can be moved are the only ones that are subject of theft. And also I said trespass to a person, those are trespass to properties, whereas I said that trespass to person is where you assault somebody or you batter somebody. Battering means you actually hit them. Assault is where you fall short of applying force on their person. It's only in Kenya where people say you are assaulted when you're actually hit. If somebody slaps you, they've not assaulted you, they've battered you, okay? Where when they just do a prank, but it's short of hitting you, and then that is assault. Then we have nuisance, so that we've covered trespass. The next one is nuisance or nuisance. Okay, that is where you're causing disturbance to a person, okay? Like a mosquito. You cause disturbance to a person. And nuisance can either be private or public. When, let's say you block the road, that is nuisance. And if you block the road such that somebody is not able, let's say they're a business person like you, and they're not able to transport their goods or transact, then they lose business. That is nuisance. It's private nuisance. There are two different nuisances. I said there's private and public. For public nuisance, it affects everybody. Like when KPLC happens, everyone is affected. That is public nuisance. But if it's only your house that is losing power, and therefore things, let's say you're a chemist and things in the fridge go bad in terms of drugs, antibiotics, and all that, you're supposed to seek compensation, okay? So for you to succeed in private nuisance, you must prove that you suffered injury that was over and above what everyone else suffered. Then you'll be compensated. That is private nuisance. Whereas public nuisance is general damage or general loss that is suffered by everybody else. Okay, then we have negligence. Negligence is, I said, it's carelessness, failure to exercise caution that would essentially lead somebody else to suffer harm. So example, if you're walking around and you're a professional and you don't have a good color of office, and then you deliver services and somebody suffers loss, that is negligence. And they have a right to sue you for professional. They have a right to sue you for professional negligence. Okay. Then we have defamation. We have defamation. Defamation are of two kinds. It can either be written or spoken. And if it's written, it's called libel. If it's spoken, it's called slander. What you guys call scandal. There's nothing called scandal under the law. It's slander, okay? So defamation is just saying something about somebody that's not true, or writing or publishing something about somebody that is not true. So if you publish, it's called libel. If you just verbatize it, if there's something to that effect, then it's called so just a recap. I said that there are many kinds of specific torts, and I said that you'll never get a book indicating to you that now this is a book of torts and limiting them. Why? Because they're unlimited, okay? And I said that they could be trespass, nuisance, negligence, or defamation. And I said that trespass are of two kinds. It could either be to person or to property. And I said that trespass to property can either be, it's classified into two, either movable property or immovable property. If it is with regard to movable property, then it's theft. Theft is with regard to movable property. And then just general trespass is with regard to immovable property like land. Then I said that trespass to person includes libel and slander, okay? And of course, we talked about so many defenses and remedies, and those ones you will come across as we go along. Of course, even false, apart from battery and assault, we have false imprisonment, okay? When somebody keeps you in a room against your will, without releasing you, then that is, they've actually imprisoned you, okay? So that is false imprisonment. And when that happens, the question then would be, what was happening and why did it happen? Okay. Then we have a nuisance. I said nuisance can either be public or private, okay? And then I explained what, I said that for private nuisance, it really harms the person and it goes a long way, while for public nuisance, it harms everybody. It is universal, it's general, okay? Then we have negligence, and I said that negligence is arising out of carelessness, where you fail in your duty of care, okay? Then I also talked about, we talked about defamation, and I said that defamation is of two kinds, libel and slander, okay? And I said that one is written or published and the other one is verbatized. So if these things are happening to you as a professional engineer, or you encounter these situations, what are your remedies under the law? Just like the law of contracts, we have damages, okay? That is money. They pay you to the extent of the suffering that you have had to bear. Then we have apology. And apology majorly happens in a situation of defamation, where somebody says things about you that are not true. Then apology must follow. Then we have injunction. Injunction, we all know, it can be positive or negative, where the court pronounces that somebody is supposed to stop doing something or to do something. Example, when somebody trespasses onto your land, then injunction is supposed to, you obtain injunction to stop them from going into your land again, okay? Whereas when somebody is supposed to do something like they're defaming you and you want them to stop, you will go to court, and what will court do? Court will tell them to stop doing what they're doing. Okay, is that okay? Any swali that far, I have made you run. Okay, swali zozote up until that extent? Kuna swali? Okay, kama hakuna swali, if there is no question, we need to jump to labor relations. Okay, we need to jump to industrial relations. And when we are jumping to industrial relations, okay, when we are jumping to industrial relations, I would like for us to look at the Employment and Labor Relations Act. Let me just note it there. Employment Employment and Labor Relations Act. Look at that. Okay. And how do you read an act? You read it by looking at its objective. And then part 2 looks at the various definitions. And then now go into the various obligations. Sawa sawa. So look at the Industrial and Labor Relations Act. When we meet in the course of the next class, I'll be looking at that. And then I'll also be looking at Trade Unions Act. And the final act that I'll be looking at will be trade disputes. Okay. So why are all this important? All this is important because it lays the basis for our next discussion, which is the engineer's obligation in the markets. Okay. Why is it important and how are we dealing with it? What is the obligation in the market? Sawa sawa. If there are no questions, then the next class I'm looking at labor relations and stroke industrial relations. Maswali?
I have a question.
Yes.
Let's say you are over 18 and then your parent grounds you in the house for, let's say, even a day. Can you sue for false imprisonment?
Sorry?
Let's say you are over 18
Yes.
and your parent grounds you in the house for, let's say, a day. Can
Yes.
you sue for false imprisonment?
False imprisonment. You are over 18. Okay. If you sue under those circumstances, if you sue your parents, the question would be, are you able to survive out there alone? Because the next thing will be, your parents will be asking you to move out of the house because you're causing them problems. So the question would be, what did you do that caused them to keep you in your room? And if they leave you to go out, is it for your benefit or not? And then finally, the next thing we'll be looking for or asking is, have you been responsible enough so that your parents are not worried about your well-being? Because sometimes parents take drastic measures for your self-preservation. So could this be a situation where they are trying to do that? So those are the questions. But if somebody, if your parent keeps you in the house against your will, then you can start proceedings for imprisonment. But before you even go that mile, the question would be, why did they do it? What was the objective? And are you responsible enough? Remember, until you have turned 25 years, the quarter of the time you're under the tutelage and guidance of your parents. So the court will not take it so seriously unless they meant harm, they didn't supply you, and so you suffered nutritional and all that, okay? Or they threatened you. Is that clear?
Yeah, it's clear.
Any other question? Okay. If there are no questions, then we meet in the next class. Give me an indication of when you're doing your CAT. Daisy's class has done. Next week we are doing, tomorrow we are doing with, I think, chemical engineers. Then the rest should give me an indication. Thank you very much.